Cool. We are now recording, Arjun.
Excellent. Hi, everyone. Firstly, good evening, good morning, whatever time you're watching this. Harry and I are doing a recording of the How to Moot workshop. In the case you weren't able to attend it, or if you're going to participate in one of our competitions in the next academic term, then this is purely for you guys to watch over, either as a refresher, if you've done mooting before, or if you are someone who is new to mooting, then it's a really good way to get an idea of what it involves and how you can kind of prepare. So Harry and I are your masters of the moots this year. Essentially, we are in charge of overseeing the competitions, but we're also here to help and support you. So if you've got any questions at all, any queries, any doubts, don't hesitate to contact us, either on our email, or if you know us personally, then reach out to us. So, Harry, would you like to kick off with the mooting journey and what it involves?
Absolutely. So the offerings of mooting that we have at Warwick involves internal competitions, a first-year competition, for example, and other external ones. The mooting journey consists of you analyze the problem question that you receive, and then starting from there, you start researching the problem. After that, you form your legal arguments based on your research from legal databases, from case law precedents, and you start combining that into something called the skeleton argument, which is a one-page document that sets out brief arguments of your case. After that, you compile the cases that you've used into a court bundle, and finally, on the day, you present your arguments in the actual moot.
So, focusing on analysing and interpreting the problem question, what we'll now go over is what you should really look out for when you read over the moot problem. This is the first thing which you'll need to do, and it's really important to essentially nitpick the key bits of information which is in it. So this is what the moot problem looks like if you've never seen it before. And the best way to kind of approach it is to kind of make a checklist of the things that you should make a note of. So the first thing is obviously the parties to the case. So in this case, it's the Crown against Walcott. So the Crown is the respondent, as is indicated, and Walcott is evidently the appellant. The next thing is to look at the case facts. So, take your time, read over the problem, and something that a lot of people have found useful in the past is kind of making a timeline of the facts of the case. This way, it will help you to kind of break down what's happening, and it makes it a lot more digestible. Another really important thing to make note of is the fact that this is an appeal case. When a case goes to an appeal, the facts are not in dispute. It tends to be, specifically about the points of law which have been applied, and that's what the contentious, that's what the kind of contention is around. The other important thing is that you're kind of contending the judgment at first instance. So this was the decision which was given at trial. And normally at the end of the problem, there'll also be the grounds of appeal, which are laid out. And as the appellant, you will be essentially developing your arguments from those grounds of appeal. Normally it's two. And then as a respondent, your responsibility is to essentially provide rebuttals to the arguments which the appellants will be making. So looking at analysing and interpreting the problem, the key thing is, and as I said before, don't dispute the facts. Mooting, unlike, say, mock trial, involves debating contentious areas of the law. So do make sure to read through the problem carefully. And as I said before, creating or highlighting a timeline of the key facts is really, really helpful. And another thing with mooting is that oftentimes the minute facts or the minute details in the case can really make a big difference. So picking up on anything which you think is relevant, anything which you think is important is really, really beneficial, and it can help build a very strong argument when it comes to the argument formation stage. Harry, would you like to go into researching the law?
Yep, absolutely. So when it comes to legal research, it's important to know what sources to refer to, how to cite your sources, but also what to actually look for. So if we proceed into the next slide, you'll find that we subscribe to two main legal databases. We've got Westlaw by Thomson Reuters, and we've also got LexisNexis. Both databases offer their own unique perspectives, so we recommend that you do use both. Additional resources are available if you talk to the law librarian. So where do you start? You identify the relevant areas of law. This is typically given to you in internal moots in terms of some cases that may be referred to in the previous in your case, but remember to keep it basic. Enter some key cases onto the legal databases and see what cases are drawn upon by the one that you're looking for, and also which cases cite the case that you're looking for. Other resources that may be available to you include the mooting sort of casebook that Origin has quite artfully created, and also obviously e-law resources, Law Tutor, etc. Just a quick heads up, please do not cite any informal websites, for example, Law Tutor, when it comes to the actual moot. The mooting casebook contains pretty much a cheat sheet of all the areas that are relevant to this year's moot, and it summarizes every area of law that you should know about. So even if you don't do law, or if you're, let's say, on a foundation year, we have truly got something for you. It's an overview of the relevant areas of law and should not be used in and of itself as standalone resources. You should still refer to the databases. Yep, Arjun, would you like to
Sure,
take
of
that?
course, yeah. So now moving on to the key tips for legal research. There are four kind of key things that you should do. So firstly, you should consult a secondary source. Secondly, you should identify the primary sources. And then thirdly, you should read through the relevant law reports. And then fourthly, of course, is understanding the case. And this is where you'll need to actually read through the case itself. Don't necessarily bother with reading the whole report. Oftentimes law reports can be, at the very minimum, maybe something like 20 or 25 pages if it's a relatively minor piece of case law, or they can be 100, 150 at the slightly less intense end of the other end of the scale. The best thing to do is to go specifically to the headings which are relevant to what you're looking for. And then from there, look for key quotes which is in the judgment, and don't just look for quotes which you'll be relying on. Think about what kind of quotes your opponents might be relying on, because this way it can give you a good way to essentially preempt your opponent's arguments, but also get a really good understanding as to what bits of the judgment that they'll be relying on. So essentially, a good part, an important skill when it comes to research is actually being able to filter out certain parts of it. So there are three key kind of questions which you want to be looking at. So firstly, you need to determine if the precedent is actually binding. So usually the decisions of superior courts are binding, and that means they have to be followed by the inferior courts. So say, for example, if the Supreme Court comes out with a particular decision, then it will be binding not only on, say, the magistrates' courts or the county courts or the High Court, but also on the Court of Appeal as well. So when you're making a particular argument, you can always emphasize the fact that even if the court might be predisposed to leaning in a particular way, fundamentally it cannot stray away from the precedent as it is binding, therefore meaning it doesn't have the power to overturn it. Secondly, you need to also consider what are the binding parts of the judgment. So there's a lot which is in a judgment, but a very important part of being a good lawyer, and obviously using analytical skills well, is kind of finding out what the ratio decidendi is. So this is essentially the decision, and it's only the decision which is binding. The obiter dicta, which are essentially informal sort of, they're essentially things which judges might say, which are not necessarily material when it comes to being binding. So they are merely persuasive, and they don't actually have any effect of binding the lower courts. And finally, and kind of linked to the second question, in order to kind of distinguish between what is ratio and what is obiter, you need to assume everything is obiter unless, firstly, the statement comes from a judgment in the majority. So oftentimes, courts like the Supreme Court, the Court of Appeal, they normally have a panel of judges, and they will normally have to essentially agree to deliver the judgment in a certain way, either they'll allow the appeal or they'll dismiss it. Secondly, is the statement directly applicable to the case facts? There's no point in using a part of the judgment which doesn't really bear any relevance on what you're arguing or what's actually happening in the case which you've been given. And finally, whether the statement leads directly to the eventual conclusion of the judge. Looking at statutes, so statutes can also be considered as part of moot problems. It's generally, from my experience, and I'm sure Harry can agree, it's considerably less common than case law. But what you have to remember is statutes are binding on all courts, and that is because of a very important principle within our constitution known as parliamentary sovereignty. However, the courts and the judiciary have the power to essentially interpret certain provisions of the statute, which may be ambiguous, or perhaps whereby the meaning is not necessarily easy to discern. And then looking at the law reports. So as I said before, reading case law reports is a very big part of legal research. And there are certain ways in order to kind of determine what the hierarchy is. So firstly, you have the official law reports. Normally, they will have those initials of AC, so Appellate Court, QB, Queen's Bench. Although I'm sure now, with the passing of the Queen, any recent case law will be under KB, the King's Bench, FAM, and then CH, which stands for Chancery. You also have weekly law reports, and then the All England law reports, which is kind of minimized to all the other. And then you also have subject-based and specialist law reports and official transcripts from the cases themselves. Harry, would you like to go over how to form legal arguments?
Absolutely. So when you're forming your legal arguments, it's important to think about how you combine the law with the facts of the case, the circumstances of your case, your research, but also other policy arguments. So if we go to the next slide, you'll find that you must always tie the relevant law into the facts that you've researched and the facts that are in the case. It is no use to simply hypothesize or to extrapolate meaning when you're not basing your argument off facts. So if you go to the next slide, you'll find that all arguments need to be backed up. It needs to be backed up by evidence. Try to rely on less on obiter dicta, but on the actual judgment itself found on Westlaw or LexisNexis. When you use legislation or judgments, pick out certain bits that you'd like to highlight and refer the courts to that particular bit. Don't just rely on other counsel's arguments, because they are just that, other counsel's arguments. You need something authoritative, and that is the judge's wording. Focus on your main submissions. Remember, you and your junior or senior partner are divided into two different roles, arguing two different grounds. If you feel like your arguments may be overlapping, it is entirely appropriate to refer the courts to your juniors or your other partner in a later bit of the moot, Try not to encroach on each other's grounds and keep to your own ground of appeal. Keep your submission as concise as possible, making sure that you're not adding extra fluff when it's not necessary. Aim for around 2 or 3 submissions per mooter. Do not go over that. I have personally seen someone with 6 rounds or 8 rounds of submission. That is simply excessive, and you will not get to that many submissions in one moot. Focus on the key bits. Remember, what you include in the skeleton is meant to be brief, but in court, you do have to elaborate. Give us a case law and tell us why you believe in your argument. You could even make policy arguments, which we'll talk about a bit later. These are arguments that are not necessarily grounded in law, but are arguments that you wish a judge would take based on a moral or a principled ground.
Yeah. Looking at forming your argument, it's important to frame your arguments in a way that will undermine those which are being made by your opponents. So if you happen to be the appellant, always anticipate and preempt what the respondents will argue. And as the appellant, you have a slight advantage in that you have a couple of minutes before the conclusion of the moot to give your rebuttal. However, that doesn't mean that you can't provide some rebuttal or preempted rebuttal in your oral arguments. If you're the respondent, again, when you get the skeleton argument from the appellants, or if you know after reading case reports or researching the area of law which is relevant to the moot, make sure to anticipate what the appellants will say, but do leave room for flexibility, because obviously a lot is said during the oral submissions, and that's when you can really get a better sense or a more detailed version of the appellant's argument. So make sure to pay attention and listen to any arguments which you think is significant, which the appellants make. And when it comes to your opportunity to deliver your submissions, it's always really important to directly respond to the arguments. After all, as a respondent, that's your role, is essentially to provide a counter argument and give the judge some pushback against why they shouldn't allow the appeal or rule in a particular manner. Harry, would you like to go over the key terms?
Absolutely. So remember to always start your arguments by inviting the courts to a particular section of the bundle. When you are drawing on a case law that is on your side, you apply the law. You apply the legal principles set out in the case and extrapolate it to the current case facts. When you find a case that may not necessarily be beneficial to your side, you can still use it by distinguishing the facts. Remember, you can always apply or distinguish the case facts or the case principles. It is easier to apply case principles even if the facts of the case that you've researched and the current one doesn't necessarily match up. You can also request that your judge, you can also overrule or disapprove certain legal principles that you think can be changed or reformed by the courts, especially if you're mooting in later stages. For example, if the setting is a Supreme Court, judges do have discretion in terms of the ruling, the precedents that bind them. So you may make an argument that precedent should be updated or reformed. Yeah, so there are 2 types of submission, like I mentioned before. There's submission in law, in principle, and submission in policy. Remember, submissions in principle are the most important. After all, a moot is about the law. You're meant to discuss the law, apply the legal principles of the present case, and argue that the judges should rule in your favor because of precedents that have been ruled on in the past. But in certain cases, cutting-edge cases, such as a case I did in an external competition with regards to COVID and businesses operating during COVID, you can draw on policy arguments. Policy arguments are judgments that should be made in the interest of fairness or justice and may not necessarily be grounded in legal principle. But remember, again, you should always rely on the law and only in cutting-edge cases, and only infrequently shall you draw on the policy aspects of when making a submission.
So, looking at the skeleton argument and court bundle, the purpose of this particular section is to essentially allow you guys to get an understanding of what these two documents are and what they should ideally consist of. So, the skeleton argument in brief is essentially a very short document which provides an overview of the arguments for both the senior counsel and the junior counsel. This is an opportunity for you guys to provide very brief summaries of what your oral arguments will be, and these come in the form of submissions. So the submissions ideally shouldn't be more than maybe a line or two long. Again, a big part of mooting is being able to communicate your arguments in a concise, but also, very much to the point manner. And then you'll also need to provide a list of the authorities. So these are both cases and any statutes which you may be referring to, alongside any law reform reports or any academic articles that you may be referring to if you wish. So looking at the skeleton argument, firstly, please make sure to include the name of the court the case is appearing in, and the court whose decision is being appealed. It's a very common mistake, unfortunately, on a lot of skeleton arguments, whereby mooters don't get the name of the court which is being appealed incorrect, particularly since it's always important to remember that the Court of Appeal has two divisions: the criminal division, which is for criminal cases, and the civil division, which is for any civil cases. If the moot problem is in a criminal case, please make sure to mention that at the top left, as is the case with this particular example, in the Court of Appeal criminal division, and again on appeal from the Crown Court. Secondly, always include the full names of the parties to the case. So if it's a criminal case, it should be Eddie Walcott, so the full name of the appellant, in this case is Eddie Walcott, and then obviously the respondent, so it would be Regina. Obviously now that things have changed, it should be Rex, as that is the Latin term for the king. Also include the date of appearance. So don't include the date which you've actually written the skeleton argument. Always include the date for which your moot has been scheduled. So even if you submit your skeleton on, let's say, the 12th of October, but your moot is scheduled to take place on the 13th, make sure that it mentions the 13th of October. And of course, make it very clear that the skeleton is submitted by the right side of to the dispute. So if you're the appellants, make sure it's submitted by counsel for the appellants, and then the same applies for the respondents. Going forward, again, with listing your authorities, a good thing, particularly if you're using cases and statutes, create two separate subheadings. So you can have cases under one subheading, and then obviously your statutes under a separate subheading. This way it avoids any confusion, and because presentation is something we look out for and we like to give marks for, making things as clear as possible but also coherent is very important. So make sure to obviously list everything in alphabetical order. And again, citing cases is a very important skill. So say, for example, if it's, let's say, the Crown against Blau in this case, include the date of the law report and then include the full citation of the official law report. So in this case, it was edition 1 of the weekly law reports found at page 1411. Looking to your submissions, make sure they are relevant to the ground of appeal. The last thing judges would like to see is essentially 2 submissions which might be very, very well written, but bear absolutely no relevance to what the grounds of appeal are actually about. And as I mentioned before, because the skeleton argument is meant to be brief, your submissions should provide a summary, a very concise summary of what will be argued. And then at the end, you have an opportunity to invite the court to either dismiss the appeal if you're the respondent, or allow the appeal if you're the appellant. And again, just for reference, when it comes to giving marks and feedback, please also include the names of the lead and junior counsel. Again, as I mentioned before, presentation is key. So do you make sure to give yourself enough time to present the skeleton neatly and coherently. Make sure to email it as a PDF both to your judge and your opponents at least 24 hours before the start of the moot. This is a hard deadline, and it would be a massive shame if the main thing to why you may not have progressed is because you missed that 24-hour deadline. So if your skeleton argument is ready, even before that deadline, as long as you're happy with it, just send it off. It's best to obviously get it out of the way, and then at least that's one thing that you've completed. So full sample skeleton argument is available on our website and in our bundle for you to kind of refer to and use as a sort of template. So Harry, would you like to go over the court bundle?
Absolutely. So the court bundle is perhaps, I would argue, the key document in a moot. It is the document that is made available before the moot to judges and also your opponents. And it's kind of like a really big file containing all the authorities that you rely on and also your skeleton argument. So without first going into too many details, it is important to note that at Warwick, we do have specific requirements for how you build your bundle. The requirements will be laid out in the Moot Bible, but also remember, don't include every page of the case. Some cases stretch to hundreds of pages when you're only citing from 2. It will make your bundle unwieldy and hard to navigate, and the last thing you want is for judges to be spending time flipping through your bundle instead of listening to you. So what we ask you to do is include the first page of a case, all the pages that you've highlighted, and also the last page of the case, and that's it. Do not include other redundant pages, just to make it easier for the judges. So your bundle should begin, whether it's electronic or paper version, it should begin with a table of contents. For electronically, we just ask you to include the page numbers, but if it's a physical bundle, it may be nice to use tabs or other visual indicators to make it easier for the judge to locate the right pages during a moot. Please include a copy of the moot problem, which is emailed to you at the start of the moot, and also a copy of your skeleton argument. Please make sure that the document is formatted correctly and make sure that it is numbered. Pro tip, the website ilovepdf.com can help you compile all these documents together in order and also help you number the pages automatically, so you don't have to spend hours manually numbering a 100-page bundle. Please also remember to include the correct version of authorities. Please try and include the official judgments, which will have paragraph numbers or paragraph letters on the side. You do not need to include the whole case, but if you can't actually find the case itself, it is perfectly okay in internal moots to include the database version. Just let your judges know at the beginning of the moot that, for example, we don't have access to the document or you can't find it. As I said before, first two pages of the case, along with the others you've highlighted, and the last 2 pages will suffice. So if we move on, we'll find this is the interface of Westlaw. You can download the law reports, the official ones, by hitting a PDF icon. You can also choose to highlight the document, but I would request that when you highlight, you also note down the paragraph and page numbers that you've highlighted, so you can refer the courts by inviting the court's attention to the highlighted paragraph, let's say paragraph A of page 3 in your bundle. It makes it so much easier for the judges to find the right page. Similarly, you'll find LexisNexis also offers this feature. Just as a heads up, our university will be upgrading to Lexis Plus this year, which will have a completely new and simplified interface. But the same deal applies. You search up a case, you click onto it, and there you can download the law reports. But there's a key difference. The case transcripts are different from the database. The database version is different from the official report. You can probably note the difference. One has letters on the side which indicate which paragraph you're referring to. This is really helpful for the judges, especially if you have multiple highlights on the same page. Refrain from using the database, refrain from using the unofficial versions if you can, but sometimes if our university doesn't have the proper access, you can still use the document. Just let the judges know beforehand. In that case, if the document does not have paragraph numbers or lettering on the side, you may consider using different color highlights or other visual indicators to distinguish between different highlights on the same page. So, very briefly, the last thing I'm going to talk about before I hand over is the bundle checklist. So, as I said before, if you cannot highlight the e-bundle, please refer to the judges to the paragraph lettering or numbers. It is so important that judges focus on you and your arguments instead of flipping the page. If you're using a paper bundle, which will be the case in later rounds, even for example, the Supreme Court final, we recommend you using dividers, tabs, or other physical mechanisms to help the judge distinguish between sections in your bundle. Also, make sure the page numbers are on the bottom right-hand corner of every page. When the judges are flipping through your document, you want to make it quicker for them to access the right section. And by including the page number in a consistent, easily readable format, you can help the judges do exactly that. An example e-bundle is available on our website and also in the Moot Bible for you to refer to and download for reference.
So, now we'll have a look at presenting your arguments. So the moot itself. And in this particular section, we're going to focus on advocacy, performance, and courtroom etiquette. These are all very important things when it comes to being a good mooter. So the running order of a moot, essentially it's broken down to 3 stages. So the judge will introduce the moot, or, the case will be introduced, which court it's in, all that. But firstly, as it's an appeal, the appellant will be the first party to the dispute to deliver their arguments. And the order it will work in is you'll have the lead counsel going first, followed by the junior counsel. Normally, the lead counsel takes the first round of appeal, and the junior counsel takes the second round of appeal. Once the appellants have submitted their arguments, normally it will then go over to the respondents. And again, it runs in that same order. The lead counsel will give their submissions first, pertaining to the first round of appeal, followed by the junior counsel, who will deliver their arguments relating to the second round of appeal. And it's important to note that a big part of the actual moot itself is being questioned on your arguments or your understanding of the area of law which is relevant to the dispute. And the judge will normally ask you a couple of questions. And it's always important, obviously, to take your time, think about it, and then respond. Once the respondents have given their arguments, then the appellants will normally have a couple of minutes to provide their rebuttal to the points of argument which the respondents have made. So looking at judicial interventions, or essentially questions given by a judge, these are not there to catch you out. It's actually a very good opportunity to convey your knowledge of the case before the court, your understanding of the case law and the facts, and also your ability to kind of think on your feet and stand your ground. Another really key tip, which can help you get more marks, is referring to an authority within the bundle. So it can be a case or a particular statute, because again, it adds more legitimacy and authenticity to your response to whatever the judge has asked you in the first place. So always make sure to answer the question briefly, then ask whether the judge would like to be taken to the appropriate authority, and then obviously you can dive into more detail. Alternatively, some questions can be answered with a policy argument. As Harry mentioned before, it's always important to have a natural flow to your submissions. Say, for example, if you are asked a question when you're making an argument which is derived from an argument pertaining to principle, then what you can always say, you can respond to the judge by saying, we will be submitting a policy argument. However, that will be under the remit of my second submission. So you can always refer the judge to a following submission. It's really important to be very direct and immediate in your response to the judge. If you plan to give a more thorough answer in your response to the question, then you can always give a very brief summary of your argument before obviously building a more detailed answer in your submissions. And always think about, particularly once you've submitted your skeleton argument, always think about what kind of questions they might ask you. That way it will give you a bit more confidence. You can kind of think about how you can respond to potential questions which might come up. And you know, in the actual moot, your response will come across as being, you know, as if the judge will get the impression that you've obviously prepared for this and you know what you're talking about. Looking at advocacy, so it's always really important to be confident. And there are a number of ways which you can kind of convey this. So maintaining eye contact as much as possible. You can also, you know, because the moots will be in person for this competition, it's really important that you don't make your speech or your arguments come across as being scripted. It's fine to have note cards or to have your general thoughts on a piece of paper, but please, please, please maintain eye contact as much as possible, and you shouldn't really be looking down at your note cards or whatever material you're relying on. Also be clear and concise in your delivery. An important part to being a good advocate is not only being confident, but also being clear. And it's important that a judge is able to, you know, alongside your opponents, they should both be able to pick up what you're arguing very easily. And again, you know, whether you're inviting the court to allow the appeal or whether you're inviting them to dismiss it, using a persuasive tone is really, really important. It can add an extra layer of sort of confidence in what you're arguing in, and it can oftentimes make a difference, a really big difference in the quality of your delivery. It's always important to use appropriate language as well. Don't be informal. You're in a court of law, so using the right language, using the legal lingo even, can really help elevate your kind of performance. And finally, the quality of your speech is really crucial. So remember, if you have 5 minutes to deliver 2 submissions, don't rush yourself. You know, take a couple of breaths in between, drink some water to give yourself a bit of a break in between the submissions. And one way to kind of really help prepare is to just do practice, just to practice with your partner. So say, for example, if you're feeling a bit nervous the night before, if you just want to see how you deliver it, have a phone call with your partner. Both of you can go through each of your arguments, and then that way you can kind of gauge how you delivered your speech and what you need to do in order to make sure that you can deliver the speech to your absolute best on the actual day of the moot. And again, having a good pace, pronouncing everything really well, projecting your voice and the tone of your delivery can really make a big difference in the end. And looking at etiquette, it's always really important to be polite and courteous to both your judge and your opposing counsel. So please, please, please don't talk when the judge is giving, asking a question, or if they're giving feedback, or when your opponents are giving their arguments. Obviously, don't fidget either, because that could distract everybody else. If you need to kind of communicate with your partner, do it discreetly. So the best way to do that is either keep a pen and notepad on the side where you can just very quickly make a note and then just pass it on to your partner, or have something like WhatsApp or some sort of instant messaging platform on your laptop, and then that way you can kind of type any sort of queries that you have for your partner, and then they can respond immediately, which is very discreet, obviously. Also, correctly refer to the judge, opposing counsel, and co-counsel. If you have a little bit of difficulty in pronouncing their names, obviously don't hesitate to ask them before the moot starts. In regards to the formalities, when you're referencing to the judge or your opposing counsel, for the judge, it should be your lordship, or my ladyship. And then obviously for your opponents, it should be my learned friend for the appellants, or the respondents for the opposing counsel, depending on who your opposing counsel is, of course. And then at the end, always make sure, whether you're the senior or the junior counsel, invite the court to rule in a particular way. So obviously, if you're the appellants, you should invite the court to allow the appeal. If you're the respondents, you should invite them to dismiss it. And finally, be professional. Don't mislead the court, because that can lead to you essentially being marked down. And in real life, it's something which could lead to serious consequences. So if you have any further questions, then don't hesitate to reach out to us. But in the meantime, feel free to access or look at our online resources. And they can all be accessed via the Law Society website. Or if you've signed up to the first year competition, then they should be in one of the emails which have been sent out. So we've got the Moot Bible, the sample skeleton argument and bundle, and then obviously the casebook. So yeah, thank you for listening.